Your doctor said you need it. Your insurance company said no. And now you're sitting there wondering how long an appeal is going to take. Weeks, maybe a month. Here's what your insurer is not going to tell you. Federal law already carved out a rule specifically for situations like yours. It forces them to answer within 72 hours. Not 72 business days. 72 hours. It's completely legal. It applies to most health plans in the United States, and the overwhelming majority of people who get denied never even know it exists. That rule is called the urgent care appeal, and by the end of this video, you'll know exactly how to trigger it, what to say, and what not to do. But first, a quick note. Everything in this video is for educational purposes only, not legal or medical advice. Every plan is different. Every state has its own rules on top of federal minimums, and your specific situation may require a licensed professional. What we're doing here is making sure you understand the system well enough to ask the right questions and fight back. So let's talk about what's actually happening when a prior authorization gets denied. Prior authorization, sometimes called prior auth or pre-authorization, is a requirement that your insurer approve a treatment, medication, or procedure before you receive it. On paper, it's a cost control mechanism. In practice, it's a delay machine. The American Medical Association has reported that prior authorization requirements have increased every single year for nearly a decade. And the standard appeals process, if you follow the default path your insurer hands you, can take up to 45 days. 45 days for someone waiting on a medication, a surgery, or a procedure that their doctor already determined is medically necessary. Here's the design underneath that delay. Insurance companies know that a significant portion of people who get denied will not appeal. Research from the Kaiser Family Foundation found that in the Affordable Care Act marketplace, patients appealed fewer than 1 in 250 denials in a single recent year. Think about that, 1 in 250. And of the denials that were appealed, more than 40% were overturned. More than 40%. That means the system is issuing denials it cannot defend, and it's counting on you not to push back. The standard process is long enough and confusing enough to make most people give up, but that's the standard process. There's another one. Under federal law, specifically the regulations implementing the Affordable Care Act, the Mental Health Parity and Addiction Equity Act, and for employer-sponsored plans, ERISA, every health plan that covers emergency or urgent care is required to have an expedited internal appeals process. The regulation most people can point to directly sits inside the ACA's implementing rules under 45 CFR, Part 147, and for ERISA plans, 29 CFR 25 60.503. What those rules say, in plain language, is this. If waiting for the standard appeals timeline, which can be days to weeks, would seriously jeopardize your life, your health, or your ability to regain maximum function, then you are entitled to an expedited appeal. And the insurer must respond within 72 hours of receiving your request. That's not a courtesy. That's not a suggestion. That's a legal deadline they cannot miss without violating federal law. And here's the part that matters most. You don't have to prove you're in a life or death emergency to qualify. The standard is whether a reasonable person would believe that applying the standard timeline would seriously jeopardize your health. Delayed cancer treatment, a surgery scheduled for next week, a medication that can't be safely interrupted. Your doctor's judgment is central to this. And that's exactly why how you make the request matters. Which question do you think gets people's appeals denied the fastest? Not because the law doesn't cover them, but because they didn't frame it right. Drop your experience in the comments. Have you ever appealed a prior authorization denial? Did your insurer tell you about the urgent process? I want to hear what happened. So here's exactly how the urgent appeal process works, step by step. Step 1, you have to explicitly request the expedited process. This is where most people leave money on the table, or in this case, leave their health on the table. When you call your insurer's member services line, you cannot just say you want to appeal. You have to say out loud that you are requesting an expedited or urgent internal appeal because your health would be seriously jeopardized by the standard timeline. Say those words. Write them in any written request. Use that language, because that language is what triggers the regulatory clock. If you don't explicitly invoke the expedited process, the insurer can and often will route you into the standard 45-day lane. Step 2, get your doctor involved immediately, not eventually. Immediately! The most powerful document in an urgent appeal is a letter of medical necessity from your treating physician. That letter should do 3 things. It should state your diagnosis. It should explain why the denied treatment is medically necessary for your specific condition. And it should explicitly state that delaying treatment would seriously jeopardize your health or your ability to regain function. Some insurers will also accept a direct physician-to-physician review call, where your doctor speaks directly with the insurer's medical reviewer. That call can happen within hours. Push for it. It puts a human medical judgment on record against their denial. Step 3. Document everything. Write down every call. Log the date, the time, the name of the representative you spoke with, and exactly what they said. Send your written appeal by a method that creates a timestamp, email with read receipt, certified mail, fax with a confirmation sheet. Here's why this matters. If the insurer misses the 72-hour deadline, that failure is itself a violation. And if you end up filing a complaint with your state insurance commissioner or the Department of Labor for ERISA plans, your documentation is your case. Without it, it's your word against theirs. So keep every record, every confirmation number, every letter. That paper trail is what turns a missed deadline into an enforceable complaint. Now, if you want more of this, the rules that insurers count on you not knowing, this is exactly what we break down here every week. Subscribing means you won't miss the next time we cover a rule that could matter for you or someone in your family. Step 4. Understand the difference between an internal appeal and an external review. The urgent internal appeal is the first move. You're asking the insurer to reconsider its own decision. Under federal law, they must complete that review within 72 hours. But what if they uphold the denial? That's where external review comes in. Under the ACA, if your internal appeal fails, you have the right to an independent external review by a third party that has no financial relationship with your insurer. For urgent cases, federal rules also allow for an expedited external review with a decision required within 72 hours of the external review organization receiving the case. So you potentially have 2 back-to-back 72-hour processes. Not weeks, not months, days, if you move fast. And here's a number worth sitting with. A report from the Government Accountability Office found that in federal employee health plans, external reviewers overturned insurer decisions in roughly 39% of cases they reviewed. 39%! Nearly 4 out of 10 times. An independent reviewer looked at the same information and said the insurer got it wrong. That's not a rare edge case. That's a systemic pattern. Step 5. Know your plan type because it changes which rules apply. If you get insurance through your employer and the employer is self-funded, meaning they pay claims directly and just use an insurer as an administrator, your plan is governed by ERISA, a federal law administered by the Department of Labor. ERISA plans are not subject to most state insurance laws. They follow the federal minimums exclusively. If you bought insurance on your own through a marketplace or directly from an insurer, you have ACA protections. If you're on Medicaid or Medicare, the rules are different again. Why does this matter? Because if you file a complaint with the wrong agency, you waste time. For ERISA plans, your regulator is the Department of Labor's Employee Benefits Security Administration, often called IDSA. For individual and small group plans, it's your state insurance commissioner. Know which door to knock on before the clock runs out. What's been the toughest insurance or consumer rights situation you've had to navigate? Tell me in the comments below. Your situation might be the next video we make. And I mean that directly. The topics we cover come from real situations real people are dealing with. If you've hit a wall with a denial, an appeal, or anything else an insurer did that felt wrong, say so. Now let's talk about the 3 mistakes that kill most urgent appeals before they ever get a real review. Mistake 1, waiting to see if the denial sticks. This is the most common one. You get the denial letter, you're upset, you feel overwhelmed, and you tell yourself you'll deal with it in a few days. But the clock on an urgent appeal starts when you receive the denial. Federal rules under the ACA give you at least 180 days to file a standard internal appeal. But the moment you're in an urgent or time-sensitive situation, every day you wait is a day you're losing. More importantly, your insurer's obligation to respond within 72 hours doesn't start until you request the expedited review. If you wait 2 weeks to make that call, you've handed them back their timeline. Mistake 2, letting the insurer define whether your situation qualifies as urgent. When you call to request an expedited appeal, a representative may tell you that your situation doesn't meet the criteria for urgent review. They may say it calmly, officially, like it's just a factual determination. It isn't. The determination of whether your health would be seriously jeopardized is not the call center representative's medical judgment to make. Federal rules are explicit. that if a treating physician says the situation is urgent, the insurer is required to treat it as urgent. So if a representative pushes back, your response is this: my treating physician has determined that the standard timeline would seriously jeopardize my health, and I'm formally requesting an expedited review. Ask them to note that in the file, and then follow up in writing within the same day. Mistake 3, treating the internal appeal as the finish line. A lot of people fight hard through the internal appeal, get a second denial, and stop. They assume they've lost. They haven't. The external review is a completely separate process with a different decision maker who has no financial stake in the outcome. Under federal rules, the external review organization is randomly assigned and must be accredited. And for urgent cases, you can request expedited external review simultaneously with your internal appeal in many situations. You don't have to wait for one to finish before you start the other. File both. Work the process in parallel. Because the insurer is not the final word. Federal law created a second opinion specifically because they can't be trusted to be. Here's our take on this directly. Prior authorization denial is not a medical decision. It's a financial one. The insurer doesn't have a doctor in that building who knows your body, your history, or what your physician saw when they ordered that treatment. The denial comes from a utilization management algorithm and a reviewer who may spend minutes on your case. The urgent appeal process exists because Congress and regulators understood exactly that. They built a legal mechanism that forces a real answer in a real time frame. Using it isn't gaming the system. It's using the system the way it was legally designed to be used. The insurer is counting on you not knowing that. So here's where we close the loop. At the start of this video, we said you'd know exactly how to trigger the 72-hour rule, what to say, and what not to do. You've got it now. Request the expedited process by name. Get your doctor's letter of medical necessity in writing the same day. Document every single interaction. Know your plan type so you're knocking on the right door. And if the internal appeal fails, file the expedited external review immediately, and in urgent cases, file both in parallel. That's the full sequence. 5 steps, 2 potential 72-hour windows, and a legal framework that forces the insurer's hand at every stage. The only thing standing between you and that process was knowing it existed. If this gave you something you can actually use, there's a video already up that goes one level deeper. What happens when the external review also fails, and the legal options that remain, including state insurance commissioner complaints, Department of Labor enforcement, and in some cases, legal action. That's the next step most people don't know exists. It's already up. And if you want to keep understanding how to fight back against a system that's designed to work against you, that's exactly what this channel covers every week.